Technically speaking, with me, Tarun Nangia. Today, we are dealing with a subject which is of utmost interest to many promoters, general counsels, and people dealing with commercial disputes. This is admissibility of electronic evidence under the Bharatiya Sakshiya Adhiniyam. This is a new law, and that is why a lot of people need clarity on how the court will look at electronic evidence under these new laws. And that is why today we'll have a special commercial focus. India is a growing economy, lot of commercial disputes, and electronic evidence is, which is sometimes the only thing, sometimes in many cases, because these days people more than meeting each other deal electronically, emails, accounts, even in a sense, a lot of documentation happens online. And that's why we take this up today. Let me welcome Justice Iqbal Ansari on the show. Sir has served as the Chief Justice of Patna High Court. Good to see you, sir, and has a keen interest in criminal law. I have also with me Advocate Shreyas Lalit. He practices at Delhi High Court and Supreme Court. Also focuses on criminal law. Good to see you too. At the outset, let me request Shreyas to make his opening comment on this subject.
Yes. Thank you so much, Tarun. It's lovely to be invited here along with Justice Ansari. Your work has been followed by many, so I hope this episode will be helpful too when I, address insofar as the admissibility of electronic evidence is concerned. Now, to start with the controversy surrounding electronic evidence, and I'm assuming that this program is being seen by lawyers and non-lawyers alike, right? So to address the non-lawyers first, I mean, obviously electronic evidence, as you rightly said, is any kind of digital data information that is, say, stored, transmitted, or retrieved using, say, electronic devices, computers, or digital technologies. It could be something as simple as, say, emails, digital documents, social media posts, text messages. Probably text messages would come on call data records, but say WhatsApp communications, iMessage, everything else will not. Audio, video recordings, etc. Right? But then when we address all of these kinds of messages and evidence within the confines of the Evidence Act or the CRPC, we see that there are two statutes which are extremely crucial, right? You obviously mentioned one, which is the Bharatiya Sakshiya Adhiniyam, which is now the replacement of the Indian Evidence Act of 1872. And obviously the Indian Evidence Act was one of the most well-drafted statutes, which is why the Bharatiya Sakshiya Adhiniyam probably does not have as many changes as well, even in terms of structure or in terms of parts or chapters. The Indian Evidence Act originally had three parts relating to, say, number one, relevancy of facts, number two, relating to proof, and number three, relating to production and effect of evidence. The Bharatiya Sakshiya Adhiniyam follows the same pattern. And in fact, chapters 4 and 5 of the earlier Indian Evidence Act relating to oral evidence and documentary evidence are also now followed, which is now the Bharatiya Sakshiya Adhiniyam. Chapter 4 is also oral evidence, and chapter 5 is also documentary evidence. Now, but within documentary evidence comes two stages, which is basically that you can prove documents through either primary or secondary evidence. Now, this is the biggest misconception that people have, is that electronic evidence is always secondary evidence and can never be primary, right? And the second misconception that people have is that because it is secondary, therefore it has to be proved through a certificate, no doubt about it. But when is the certificate supposed to be produced? Is it supposed to be taken out? Is the certificate supposed to be taken at the time when you produce the evidence? Is it supposed to be produced at the time when you furnish the charge sheet? Or can it also be produced at the time when the person is giving testimony before the court, right? So there are a few sort of gray areas which obviously have been clarified through Arjun Panditrao Khotkar. But before we deal with Arjun Panditrao Khotkar, I think it is important to first understand what is primary and what is secondary evidence, right? Because that is the entire landscape, should I say, of the admissibility of electronic evidence. Primary evidence is obviously all your original documents, anything that is contained in the device, and that is the one single solitary unique copy of the same, and there is no possible other reproduction. A reproduction or a copy of the same would become secondary evidence. So all your contracts, wills, all original contracts and original wills will become original documents. Your photographs, if they are contained in the camera in which it was taken, that camera will become original evidence or primary evidence. However, if you are obviously downloading something from the internet, then the original is contained in the server and your download is a reproduction of the original. So therefore it becomes secondary evidence, right? So this is obviously a very sort of layman and sort of introductory understanding on what is primary and what is secondary evidence. Now, come to 2000, obviously the Indian Evidence Act could not have possibly in 1872 contemplated that there would be something as vast and disruptive as electronic evidence. So 2000, we get these new sections 65A and 65B. Now, what is interesting about 65B is that I'm talking about the earlier 65B, which is now section 63 of the Bharatiya Saksha Adhiniyam. The 65B and 63 of the Saksha Adhiniyam, there is hardly any difference. 65B would obviously start with a non-obstante clause, and so does 63 of the Saksha Adhiniyam. But what is now important, and the reason why electronic evidence has now become so crucial, is that you have had now multiple changes in the CRPC as well, which is now your Bharatiya Nagrak Suraksha Samhita, which is the new CRPC. And in that new CRPC, now you have several sections in which, say, for example, identification of persons is to be done through audio-video means, or your search and seizure has to be done also through audio-video means, which means the list of seizure that is prepared, or the signature that you have to take at the end of the list, all of that has to be prepared through audio-video means. So electronic evidence has now become extremely crucial. Now, following up to Arjun Panditrao Khotkar, obviously there have been multiple changes, starting with your Parliament attack case where they said 65B is not necessary. Then PV Anwar came where Justice Nariman was also there in that combination. So it was, I think, a combination of Justice Lodha, Justice Joseph and Nariman, from what I remember. And the judgment was given by Justice Joseph, and he said that obviously, 65B is extremely crucial. It cannot be done away with. A certificate is the most mandatory thing. Now, the complication comes that PV Anwar itself says in one para, because I've just recently argued this, so I remember para 24. Para 24 of PV Anwar said that you can produce electronic evidence as primary evidence. And if it is produced as primary evidence, that is, if the original itself is produced before the court, and the court can itself play the recording or play the photograph or whatever it is, then there is no requirement of a certificate. And that is what PV Anwar said. Now, skip to 1 year later, you had, the person who wrote PV Anwar was Justice Joseph. And Justice Joseph is part of another combination in Tommaso Bruno. And Tommaso Bruno now says that, PV Anwar obviously doesn't consider PV Anwar, but it also says that 65B requirements otherwise are met. But in any case, you can prove electronic evidence through secondary evidence. Now, this became a big question mark, that how can, any judge or any court say that? Because right in the light of, PV Anwar having said that 65B is mandatory, how can Tommaso Bruno now say that, electronic evidence can be proved through secondary evidence? Cut to 3 years later, again, there is a bench presided by Justice Goyal. They do consider PV Anwar, but they also note that, PV Anwar has given that, that loophole, that you can produce electronic evidence as primary evidence. And if that is the case, you don't need a certificate. And the entire controversy came down to then in 2020, which was Arjun Panditrao Khotkar, where it then settled the law insofar as 65B is concerned. So Arjun Panditrao Khotkar did two things insofar as previous judgments are concerned. Number one, it declared Tommaso Bruno, which was also a 3-judge bench, it declared it as per incuriam. And number two, Justice Goyal's order in Shafi Muhammad, it said that it overruled it on the ground that 65B being mandatory and you can't, misread PV Anwar like that. So on these 2 points, Arjun Panditrao Khotkar is quite clear that now 65B is mandatory, except in a situation, and now it has given a very small loophole, that in a situation where the person who has produced the electronic evidence is not in possession of the device, then how can that person give the certificate? So the certificate obviously needs to come from a person who is in possession of the device, for him to say that, yes, these are the device particulars. This is where the computer output was generated from that device. And this device is in my possession and control. But obviously, if he doesn't have that device, then how does he give the certificate? So Arjun Khotkar left that one possible area, that loophole alone, and it kept that alive to say that in such a situation, then a certificate is not required, because obviously then you do not have any other opportunity but to ask the person who has the device to produce the certificate. And if he also doesn't produce the certificate, then there is no other option but to admit that evidence. So I think these are, my initial introductory remarks. I think we can dive deep into it further as, we also hear from Justice Ansari.
Thank you. Thank you for that opening comment, Shreyas. We'll go to Justice Ansari for his observations.
Mr. Tarun, we have to first understand it very clearly that there has been some pragmatic and I will say rather recent changes in the procedure. What has happened is this judgment of AMU has become very famous now, whether it's a minority institution or not. The controversy is as to why it has not been decided by the 7-bench judge. Why that AMU is or is not a minority institution, why it has been left to a third 3-judge bench to decide whether AMU is or is not a minority institution. The practice has been, and I think is right, that when a matter is referred to a larger bench, or when a matter is considered by a larger bench because of the nature of composition, something has been decided by 2-judge bench and it comes before the 3-judge bench. When it is a reference, then in that event, the only question which is divided is whether the reference is valid or not. And then it is sent over to the original bench for decision. Unfortunately, today Supreme Court follows this hybrid system of deciding both the cases. Sometimes it is deciding itself, sometimes it is not deciding. That is why, in fact, in AMU case also, Justice Chandrachud heard the matter as if they is going to decide and then left it. And that's why Justice Dipankar Gupta has given a dissenting note that why we have invested so much of time and let us divide. Similarly, in this case, when the judgment is of the 3-judge bench, you have another 3-judge bench. You can tell that the 3-judge bench to per incurium, but you cannot decide and say that this is per incurium, so I am deciding what is correct law. No. You are of coordinate strength. You refer to a larger bench, and the larger bench will decide what will happen or not. In this particular case, as we can understand, Justice Goel bench has done the same thing. They have pointed out it is a per incurium and then decided what is the law. Notwithstanding this preliminary prefatory remark, now coming to the subject matter today, requirement of giving certificate is a statutory requirement. And as Mr. Lalit says very correctly, that the question of giving of certificate will arise only when you have the system with you. And if you do not have, then you can't give the certificate. And that position, I think, is very clear. The difference is that Macaulay must be given all credit for the way he used to think. In the evidence, you will find that it says that once the original is made, and if any copy is made mechanically, then every piece of evidence is a primary evidence. That means even before this electronic evidence came into existence, Macaulay had already perceived a situation where every evidence will be primary evidence. That means if by way of mechanically, when you make Xerox copies, then every copy is a primary evidence. Similarly, in the case of electronic evidence, whatever is produced by the hard copy, provided you have the server with you, then it is a primary evidence. Requirement of giving a certificate is that it has not been manhandled, or rather it has not been handled. Because if you download from somewhere a particular material by email, it is obviously you don't have, as Mr. Lalita correctly pointing out, that you do not have the material with you. You are not the owner. So you will have to testify that it is original. That is the certificate requirement.
Point well taken. I'll go to. So you want to say something more before I go?
No, it's all right. He has done it so well, Mr. Lalit, I must say.
Okay, thank you. I'll go to Shreyas. Lalit. Shreyas, two things I want to know from the promoter's point of view, from a businessman point of view, who is dealing into various transactions, many commitments are made online. What he must know as far as the new laws are concerned. I'm talking of a person who goes about his daily business, and of course he has a GC, but in these days promoters get into matters, they have to know. In their language, what would you like to share with them? That what has changed with the present laws?
See, what has changed, like I said, there has been a simultaneous sort of introduction or emphasis rather on electronic evidence in both the CRPC as well as the Evidence Act, which then gives the police officers enough power. Say, for example, they were to search your office or seize certain items. Then something taken through video means will, and assuming that the certificate is produced and you have been able to create, and establish all the links, that video evidence is always seen as more trustworthy than the word of a police officer, or will rather, when it plays out in courts.
May I ask you a question to interject? In the times of artificial intelligence, when electronic evidence has a risk of fabrication, it can be fabricated.
Absolutely.
Do you think that this is a territory that the courts have not yet, in a sense, faced? Because I mean, in the end, the courts need to go through so many cases to arrive at a certain level of understanding. Do you think that will pose a challenge to investigators and judges alike?
Oh, absolutely. I think now, because of your large language models, and with the kind of disruptive AI that we are seeing now, you can just change somebody's face and plant it on somebody else's body. And this is, there are so many other cases, IPC offenses, and there are revenge porn cases. There are cases of, of morphing and fabrication of images and videos against celebrities, where celebrities have been shown to be in certain, compromising positions, whereas they were not. So there are all kinds of, fictitious sort of images and videos circulating, and AI is extremely disruptive. You're absolutely right. And we also haven't faced such a situation. So in these circumstances, there is something, and it is something that would be preferable if the prosecution uses it, and if they don't, then something that the accused persons can possibly utilize, is that whenever you are to sort of create a reproduction of electronic evidence and therefore just store that evidence in a computer resource, it is extremely important to start implementing this practice of hash value certificates. Now, hash values effectively are what? Say, for example, I were to download some data, right, from a computer, and I were to store that data in a hard disk, right? Now, how do I show that this hard disk has not been tampered with? The only way I can demonstrate that this hard disk has not been tampered with is if I can create a unique key that can be generated from this hard disk, which unique key will change every time I make an alteration to this hard disk.
Okay.
So that is a hash value.
Okay.
So say, for example, even if I were to just copy the contents, it could literally just be a Word document saying, my name is Shreyash Lalit. And I could make a copy of the same Word document saying the same thing, my name is Shreyash Lalit. But because it's a copy, there will be a new timestamp, there will be a new modification, and the hash value will change.
Will it have a timestamp every time?
Have a timestamp as well.
Okay. Okay.
So these are sort of the new, best practices that are used when it comes to digital forensics. And hash values have been in vogue for some time. Yeah.
It's a good point. I'll go to Justice Ansari. Sir, I'll take you back 4-5 years when we did shows on DNA evidence and ocular evidence. And eminent criminal lawyers used to say that in rape cases, body fluids can be planted, and some people can be fixed in a false case, and they are sentenced. That is one part in the olden times when that kind of planting. But in the digital world, with artificial intelligence, hacking also happening, do you think judiciary is currently equipped to deal with the technological advancement that the advent of AI has seen? I mean, is the judiciary ready today, in your view, to take such cases on?
Always follow events. So you can't say judiciary is ahead of the events, cannot be. So it is still following. And as you have pointed out, artificial intelligence can disrupt everything. And that is why it has become all the more important for Indian judiciary. Merely reading of a judgment will not do. This kind of awareness program that you are holding will go a long way for the lawyers and the judges, or for the lawyers in the making, to understand as to what is the primary evidence in the matter of electronic evidence and how to prove it, and what destructive aspects can be there with the help of the artificial intelligence. And as Mr. Lalit has correctly pointed out, that when you are downloading a electronic material, you give your hashtag. But remember that every time you create a copy, it will have a different hashtag, and even the timestamp will change. Obviously, because timestamp will not be what it is. I remember a case, if you allow me a few minutes, when Whole India introduced the electronic evidence first time, electronic auction. A case was filed that in the state of Assam, the electricity position is very bad. So this electronic auction is taking place, supposing in Delhi. So by the time I reach Delhi, people in Delhi have already given their bid. So then that is saying that there could have been a process of time stamp which Whole India Limited had not put till then, because the time stamp was still evolving. Today we know that there is something called time stamp. When you arrange it, this time stamp will tell you at what time it was received by Delhi unit. So that problem which arose in the past will not arise now. But the fact of the matter remains that law will have to keep chasing the events. There is no other option and there is no shortcut.
Okay, point well taken. We'll take one final comment from Shreyas Lalit. In a particular commercial case where thousands of emails are to be relied upon,
Yeah.
and if 10, 12 key documents are fabricated, that could change the fate of the whole case. Given how complex law has become, do you see the judicial system as it is today? Is it equipped to adjudicate lawyers and judges both? I'm talking of, because you're talking of huge amounts of data, emails, electronic communication, and then the ability of some people to hack those. What is the missing piece of this puzzle, do you think, that needs to be solved today?
I think in terms of the judiciary being equipped, I don't see any problem in the judges being able to handle it. The only problem that I see is the missing link in terms of explaining to the judges
Okay.
that how exactly was this fabricated, right? So I personally find that there is a huge hole available, and there is a huge, gaping hole in the market insofar as digital forensics are concerned, where experts are made available to determine your digital or electronic evidence and then demonstrate to the court as to why this digital evidence could possibly be fabricated or there could have been an alteration of the same. Now, these are very complicated matters. Very recently, some matters came up to the Supreme Court. And sometimes judges are not adept at understanding, sort of the technological advancements. So more often than not, they look at a certificate and they say, okay, very well, the certificate says whatever it needs to. All right, the certificate does mention particulars. It's not just about the certificate, it's also about the evidence, right? What kind of evidence has an expert come and given to say that, okay, the evidence that the prosecution is relying upon cannot be possibly, authentic. And there are so many instances like this. Say, for example, you have call data records, right? A nodal officer from, say, Airtel or any of those other mobile service providers downloads the call data record, and then clubs the two call data records together and prepares a summary, right? Now, say for example, if something like this is being done, obviously the computer output directly from the computer would be secondary evidence. But if you are putting two Excel sheets together for two different numbers, and then you are presenting it to the court, naturally the court must also be in a position to understand that whether this is a direct output of the call data record, whether this has been, manually, there is some manual intervention by the nodal officer, right? So some simple things like this, say for example, you will require obviously experts to come in and, be able to bridge that gap. Otherwise, courts will not be in a position to understand. So
Thank you for that. You're saying something, sorry.
no, I was just saying that in terms of technological advancements, I do think that, judges can possibly understand. Like I said, I mean, that expert, that gap needs to be there. I do see a lot of firms now coming up with some sort of white collar advisory, etc.
So basically,
emails and understand.
you are saying that the way the court has assisted by the lawyer needs a lot of improvement in terms of, okay,
Absolutely.
point taken. I think this was a good discussion today. In our next show, we will deal with particular cases where we should be able to discuss particular cases in which electronic evidence was perused by the court and adjudicated upon. I think it will be a great learning even that ways for many people.
That will be interesting also.
Yes. So, in which we can take your observations. Shreyas can come in with the explanation of the case flowed, because I think that would give a much more takeaways in that sense. 2-3 cases, I think in the next shows, we should be able to take up one case a show or maybe 2 cases a show. But I really appreciate that.
The best example is that of Arjun Khotkar only. Because in Arjun Khotkar's case, he filed a nomination which was to be filed by 3 p.m. And the video showed that he actually filed it by 3:30 p.m.
Interesting. So we could take that up also in the coming show. But really appreciate that Justice Ansari, Advocate Shreyas, Lalit, you both made time, came on this very interesting episode, which a lot of people want to know more about because they are dealing with electronic evidence, and this will serve the cause of justice and adjudication, and also in a sense, even for a lot of other lawyers, this is something that they have something to take away from. Thank you for joining us and appreciate your time. Thank you so much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.